Hello, I'm Jim Windsor with the law firm of Kaufman Canoles in Virginia Beach. I am very appreciative for the opportunity to be here with you. When I have given these types of seminars over the years, I always invite everyone watching to pick up the phone or email me if they have any questions. I'm always delighted to help a fellow member of the bar or a colleague, and just delighted to hear from folks and pitch in if I can. As far as I'm concerned, we're all in this together and all colleagues in the practice of law. As a obscure and little-known band said from last century, we'll get by with a little help from our friends. A little bit about my background. I have been practicing real estate law for over 38 years, primarily in the area of real estate litigation. However, my career and interest in law started in college when I served as an intern with a local law firm, and a partner there named Ace Blatt taught me to examine a title to real property. And as with Paula, title examining taught me a skill and gave me some basic real estate knowledge. And frankly, that early experience and someone taking an interest in me and showing me how to examine a title is what ultimately leads to me sitting here today. I'm going to mention some mentors because mentors are important. Find someone who's willing to mentor you and serve that person well and give back and follow direction, and it will help you immensely in your law practice. Many folks are willing to do that. After my first year of law school, I worked as a title examiner with a small firm in Hampton. After my second year in law school, I worked for Hunton & Williams, a large firm in Richmond, doing title examining. Then I joined a small 17-person firm in Norfolk in the real estate section, had another terrific mentor, David Sutland. And then in 1987, I joined Kaufman Canoles in the real estate section, met Paula, who, again, I've considered a good friend and colleague for over 40 years, and have thoroughly enjoyed working at Kaufman Canoles in their real estate section and in Hampton Roads. So with respect to easements, Paula did a wonderful job in going over her topics. So I'd like to turn next to an easement by prescription. To establish an easement by prescription, it is necessary to prove by clear and convincing evidence that the use of a land of another, which is what the easement is all about. As Paula mentioned, there's a servient tract and the dominant tract. You can think of the servient tract as being you're serving the dominant owner who's using your land for another purpose, and the dominant owner is, in a sense, dominating the use of the land or the servient owner for that use. But it's a two-way street, as we'll see. The elements of a prescriptive easement are that the use must be adverse under a claim of right or color of title. We're going to go through what each of these means briefly. Exclusive, continuous, uninterrupted, and that the use has continued for at least 20 years. If you want to think about an easement by prescription as the equivalent in easements of adverse possession is where one uses the land of another for 15 years, basically the same elements, and acquires ownership. A prescriptive easement is when you use the land of another for ingress and egress or some purpose for 20 years, and the result is, under the law, if you meet all the elements, a prescriptive easement. Let's touch upon each of these issues and elements. Adversity. It is adverse if you are asserting a claim of ownership to the land of another. You must, seek an ownership interest in the land. Now, having said that, where there is open, visible, and continuous and unrestricted use of a roadway, say, it is presumed to be under a claim of right. Now, why is that important? Because it results in a legal presumption that the owner, the user of the road has. So if you are in litigation, the party using the road starts with a presumption, and the other side has to, although might be the defendant, and typically the plaintiff will have the initial burden of proof, the plaintiff in this case would start with a legal presumption, which would then have to be rebutted. So it's very important to understand that merely using the land of another in an open, continuous, notorious way will establish in easement the adversity element. It must be exclusive, meaning not in common with others. It must be continuous, uninterrupted. What if you don't use it for 3 months? Well, that's interrupted. It's not continuous, so that's an important element. Now, the use has to be in connection with the nature of the land. For example, timberland, it is common for a timber company to go on land which is rural usually once or twice a year. That level of use, if it is normal and customary for that type of use, will be sufficient to establish continuous. It's not necessarily daily, but it's continuous and regular with respect to that use of the land. What are some common issues that come up? There is some case law about having a mistaken belief versus a general belief. And let me mention a couple of cases and how that works. Where one seeking an easement harbors a mistaken belief that he has an express easement, then he cannot form the requisite adverse intent to own the land of another, because he believes he owns the land through a mistaken belief based on an express easement. However, where someone has a general belief that they own the land of another and has the right to use the easement, then he can maintain and claim and ultimately obtain a prescriptive easement. This is a case of Cheney versus Haynes, 250 Virginia 155. Now, is actual knowledge of the servient tenant necessary? No. It is only necessary that the user use the land in such a way that a reasonable person would know that the owner, the person seeking to establish the easement is using it. It's open and it's notorious. They may have built a house. They're not only using it in the middle of the night. Now, where use starts out as permissive, it will not ripen into adversity. Also, the use has to be in a definite line. If you're trying to establish an easement over a road, you have to, and it's a 10-foot road, you have to stay within the confines of the 10-foot road. Stay in your lane rather than weaving in and out. So you have to file a different route. And of course, you cannot acquire an easement over public land. Let me touch on easement by estoppel. Easement by estoppel, the leading case and the one that you'll see how an easement by estoppel can develop is called the Bershader case, 258 Virginia 75. In that case, the developer told some folks who were going to buy property, you see that lot over there? It'll always remain park-like. I'll never develop it. So the couple bought the lot. The builder immediately after they closed started to develop the lot, and they said, wait a minute, you told us that would always be a park-like setting and you never develop it. And the court, and went all the way to the Supreme Court, said that we're going to say that by making the representations that lot is encumbered, although not of record, by a negative easement where you cannot build on it. And the court went further and said that easement will be appurtenant to the land, and the decree was recorded, and so that's an example of an easement by estoppel. Others are a case Only versus Buena Vista, 104 Virginia 580. In that case, Mr. Only built a bridge and said, I built the bridge, come build on the lots that are adjacent to the bridge. A number of people did, and then later he let the bridge fall into disrepair and was about to tear it down, and the landowner said, you can't let the bridge fall into disrepair, you need to repair it. And the court said, no, you lured these people in, you induced them to buy your lots with the bridge, and now you're stopped from tearing it down. The location and width of the easement, if it is established by a deed or a plat, if the plat says it is 20 feet wide, then the plat will control the width of the easement. Where it is expressed or implied, it is defined by the use of the easement, not only in terms of the width or the length, but also the scope of the easement. An implied easement can be moved. It can change over time. There's a case, Buxton versus Murch, 249 Virginia 502. An easement can be express. It must be restricted to the terms of the grant. Most deeds will say an easement for ingress and egress, but others will describe the purpose for residential purposes, for purposes of hunting. And it will be restricted to that. An easement by necessity is restricted to the necessity itself. And an easement by prescription is necessarily prescribed to the historical use. There's a case out of Hanover County where the road was 10 feet wide and it was only used for hunting for the entire 20 years. And the court said, that's all you get. They wanted to they wanted to have a 50-foot road and a 20-lot subdivision, and the court said, no, that's not the use. You've exceeded the scope of the use. With respect to increasing the burden, this is some old-time PowerPoint. You have 2 lots, and there's an easement that serves 2 lots. Now, what if the owner buys lots 3, 4, and 5? Can the easement serve those? No. You cannot add on lots that increase the burden. Now, it's a dichotomy between increasing the degree of the use versus the burden. You cannot add on lots, but what you can do, and what the courts have said is, there's a case called IKEA, where you went from 80 boat slips to went from 84 boat slips to 280 slips. That may sound like an increase in the burden, but it's an increase in the degree and is permissible. Termination of easements. It can be expressly terminated. There can actually be a document, termination of easement. Abandonment, which we'll talk about in a moment. Where the easement by necessity created the easement, there was a severance and the land became landlocked. If the necessity no longer exists, then the easement no longer exists. It evaporates with the lack of necessity. With respect to termination of purpose, if the purpose for the easement, let's say it was to get to a public road and it no longer reaches the public road, then the purpose of the easement, the express purpose, will terminate. That is 61 Virginia Circuit 287. And finally, Paula mentioned this, termination by merger. If the servient tract and the dominant tract are joined by a common owner or will become owned by a common owner, then the easement will merge out of existence. And that case is 250 Virginia 271. I hope this has been informative. And again, if you have any questions, give me a call, send me an email. Always delighted to help a member of the bar and a colleague and someone seeking to learn. Thank you.